That was my experience. I love out here in West Texas. And he's saying, it's not a very sexy thing to be going into. So whatever company you need to run your title every time you get a new list or something. So he's saying they're charging $500, $700 to do it. Yeah, exactly. Well, that sounds pretty good. I didn't know about Sweetwater. Nice to meet you, Mr. Sullivan. Reese, 3L here. I'm sorry. Reese. Oil and gas one? All rise.
Please be seated. City Council chased away the audience. Okay, be that way. There's a few in here, and they're the important ones, so thank you. The second case that we have this morning is 07-21-00183-CR, Angel Mungia versus, I'm assuming that's how you pronounce it, Mungia versus State of Texas. The appellant's ready.
Ready, Your Honor.
And the appellee ready? Okay. And before we start, I just do want to say that we did have a panel change from this morning, and joining us for this argument is Justice Pirtle. As you probably know, that he's been on the court for many years, and before that he was a district judge for many years up in Amarillo, and we're glad that he's joining us for this argument.
This is out of my old court.
Excuse me?
This case is out of my old court.
Hopefully it wasn't pending back then, too.
I hope not. That was 18 years ago.
The question is statute of limitations, so a long time. With that said, Mr. Combs, and there's sometimes an acoustic problem in here, so try to straighten up the microphone, either lean towards the microphone or pick up the microphone because it gets harder to hear sometimes.
May it please the court?
Counsel.
Ms. Smith? Your Honors, really this case comes down to the term court of competent jurisdiction. In 1205B, which is so long as a pleading or charging instrument of some variety is filed in a court of competent jurisdiction, then the applicable limitations is told. Now, there's some other conditions in 1205 that don't apply here, like being out of state or something of that nature. But the focus, or the two things that work together, which I believe means that this court should overturn the trial court's decision on the motion to quash, is that, one, a mere complaint does not place a criminal matter before a court of any sort, in a felony at least, and two, that allowing a mere complaint to toll limitations means that 1201 has no effect because the state can willy-nilly file complaints without having to seek the indictment that the Texas Constitution requires.
Okay, you're,
So-
I'm sorry, go on.
The Constitution speaks in terms of an indictment or an information, and we don't have either in this case, except for
Correct.
for after the date that limitations had expired.
Exactly, Your Honor. And, well, in this case, there was no information ever filed. There was a complaint pending for just barely over 3 years, and then an indictment was sought, and of course, granted.
You're doing something, your position is such that you're doing something that a lot of courts don't necessarily like. You're inviting us to reverse our precedent.
Yes, Your Honor.
Okay. And that's what I want to hear is why should we reverse our precedent?
Because, Your Honor, Ex parte Aloha, which was originally an appeal, it was originally in Montgomery County down by Houston, and then appealed to, one of the Houston appellate courts, and then further up to the Texas Court of Criminal Appeals. The Texas Court of Criminal Appeals gave us the instructive language in Aloha, which was, of course, in 2017, long after, I believe, the court's asking about Bonner.
In 92?
Yes, Your Honor. Well, in 2017, the Court of Criminal Appeals told us that as long as an information is pending in a court of competent jurisdiction, then it's considered to be pending for purposes of Article 1205. Because in Aloha, an actual information was filed with the 221st District Court.
Counsel, was that not a statement of the facts as opposed to a statement of the law? Because the tolling provision of the statute specifically includes the word complaint. So the Court of Criminal Appeals is only saying, in this case, limitations was told because an information was pending, but the statute itself includes complaints.
It does, Your Honor. But in this case, in Mungia versus State of Texas, the complaint was not pending before a court at all. In fact, as I
What's
bring
the, the significance of a complaint? What's the legal status of a complaint?
as far as a felony is concerned, Your Honor?
Just as far as an instrument, what do you say it is? Is it a charging instrument?
Only for a Class C misdemeanor, Your Honor.
Okay.
As far as a felony is concerned, a complaint is just hopes and dreams.
It's a what?
Hopes and dreams, Your Honor. It's not a charging instrument.
Well, was it Drummond or Ulia, the CCA discussed what a complaint does, the three categories of a complaint. And one of them was a complaint can lead to an arrest warrant.
Yes, Your Honor.
And a complaint can also be a charging instrument. And I'm assuming, I think that was Drummond, where they said here we're looking at it as in terms of a charging instrument. And I think Drummond came out a little bit before Ulia, where it was a complaint. But the court nonetheless said that was enough to invoke jurisdiction.
Oh, Your Honor, Drummond, if I'm remembering correctly, is where the Court of Criminal Appeals held that a complaint, if it happens by chance to have all the information required for an information, it can function as one.
Does the complaint here do that?
No, Your Honor.
Why not?
It's not filed with a court of competent jurisdiction.
It was filed with the district clerk?
It was, Your Honor, but a clerk is not synonymous with a court.
So are you saying somebody has to actually take the complaint and give it to the trial judge?
They have to the state, in this case, Your Honor, since they're the one wanting to pursue the case, has to ensure that it ends up on a court's docket. In this case,
But isn't that the function of the district clerk, to assign it to a court?
if it is, Your Honor, they still didn't.
How did it get to the court that denied your motion to quash?
The indictment, Your Honor, which was sought and received from the grand jury after the 3 years from the date of the offense.
Okay, so clarify. You're saying whether it's a complaint, an information, or indictment, it's not enough to file that with the appropriate clerk. Somehow, the state has to assure that that clerk assigns it to an appropriate court.
Yes, Your Honor. They're the
Can
ones.
the state dictate what court it goes to? We've got
Generally-
several courts, district courts up in Amarillo. Can they say, well,
Yes.
we want it in this one? Or they just say, we want it filed in a district court?
Well, Your Honor, I would suggest that a mere complaint can't be filed with a district court because it's not a valid charging instrument for a felony.
Well, according to Drummond, a mere complaint, if it has the elements of information, is enough to charge an offense in a non-JP court.
If no one objects to it, Your Honor, and if it by chance actually ends up in front of a district court.
Let me ask you this with regard to the complaint here and the information. One of the elements or requirements of an information is that it has to be signed by the prosecutor, the district attorney,
Yes, sir.
okay? Was the complaint here signed by the district attorney?
Yes, Your Honor.
Where is his signature?
At the bottom, Your Honor,
At the bottom of
of the complaint.
the affidavit? There's only one complaint, correct?
Yes, Your Honor.
In its form of an affidavit, correct? Who's
Yes.
the affiant?
The arresting officer.
The police officer.
Yes,
Okay. And the police officer is the one that signed it, correct?
correct.
And where is the district attorney's signature?
Like below the officer's signature attesting to it, Your Honor.
As the notary?
Yes, Your Honor.
So was being a notary enough to satisfy the requirement that it has to be signed by the district attorney?
In all honesty, Your Honor, I believe that's how you could read Drummond as holding.
Well, Drummond really didn't address that.
They didn't, but they listed all the requisites of an information and said, if a complaint has all these things.
Mr. Crum, in this particular case, as a result of this complaint being filed with the district clerk, a warrant was issued.
Yes, Your Honor.
Does a district clerk have the authority to issue a warrant in and of their own authority?
No, Your Honor.
Only a court has the authority to issue a warrant.
Yes, Judge.
So the district clerk, in issuing a warrant on this complaint, was acting for whom? The clerk or a court?
They were acting for Judge Estevez in this case.
Well, when the
But-
original complaint was filed, they weren't acting for Judge Estevez because you just told us it wasn't filed with any court.
It still wasn't, Your Honor. In this instance, by happy circumstance, I guess, Judge Estevez, who is right now the district judge of 251st, was also the magistrate back in 2017 when this case first arose on the offense date. She signed the warrant after the complaint was filed, but the warrant doesn't list a court. It just lists her as magistrate.
Does a warrant toll the statute of limitations?
No, Your Honor. It's because warrants aren't charging instruments.
Well, but the magistrate is not acting, or is acting as a judicial office they're issuing a command to the sheriff to seize a person on a criminal complaint. That's acting as a judicial, that's in a judicial function. Why is that not a court of competent jurisdiction?
It could be, Your Honor. It isn't necessarily, because a JP court can act as a magistrate and issue a warrant based on a complaint, even in a capital murder, but they, of course, couldn't try the case.
Because under the government code, the magistrate doesn't have a separate court. The courts are the district courts or the county courts at law.
Exactly, Your Honor.
And they magistrates for or on behalf of the district court in this instance.
Yes, sir.
Let me ask you, with regard to the warrant that's issued, and I don't know the answer to this, never thought about it, but is there a return? Does the warrant have language in it requiring a return once he's arrested, that he's got to be brought before somebody or anything like that?
In this instance, no, Your Honor. He was, if I'm remembering correctly, mind you, it is on the clerk's record. The return was returned to Judge Estevez in her capacity as magistrate, but not in her capacity as district judge of the 251st.
So the return doesn't mention a particular court?
No, Your Honor. In fact, something I mentioned in my reply brief, Your Honor, in September of 2020, Judge Estevez, after Mungia had been arrested, she signed an order appointing him counsel. And that order says, no judicial officer assigned at the top of it. In Judge Estevez's signature block, it says no judicial officer assigned. And this order is in the clerk's record filed in this case. That's why the key here is that the complaint, even assuming it is enough to toll limitations in a felony, which I don't believe it is, it was not filed with a court of competent jurisdiction.
I think the state's brief uses the term felony complaint. Is that defined anywhere?
Not really, Your Honor. Complaints generally don't distinguish between misdemeanors, felonies. Anyone can swear out a criminal complaint about anything, really, that's an offense against laws of the state of Texas. But to proceed to trial on a mere complaint in a felony would be unusual.
And so your position is then that the filing of a complaint does not act to toll the statute of limitation?
Correct, Your Honor. And I believe that Aloha gives us court grounds to overturn Bonner because Aloha drew the distinction between a mere complaint versus an information. And again, in Aloha, where an information was enough, because the Constitution allows that, even for a felony, it was actually filed with the 221st District Court instead of just the district clerk, and then not acted upon by the court.
But your argument, you're conceding that the complaint here has the requisites for an information, and your point for reversal is that it was, even though the complaint has the requisites of information for purposes of Aloha and Drummond, it was never filed with the court. That's what you're asking for reversal on.
Well, off the top of my head, Your Honor, I don't have that actual complaint in front of me. I don't concede that point. Okay. The court may find it does. That's y'all's prerogative if you do, Your Honor. But we're certainly not conceding it. What I'm saying is that even if it does, it's not enough because it wasn't put before a judge to proceed to trial on that charging instrument. The sole purpose for filing a complaint was to ask a magistrate for a warrant, and then nothing happened until well past statute of limitations.
Okay. you still have the statute that says the same thing as it said in our Bonner, that you exclude from the time of calculation, the time that the complaint or the indictment, the information, or complaint, quote unquote, or complaint was pending, correct?
Yes, Your Honor.
Why can't we just say the legislature expressly said you got it, a complaint is enough? And that's what basically we said in Bonner, correct?
It is, Your Honor. It's almost identical facts, different offense, but otherwise identical because that's been the common habit of the Potter County District Attorney's Office for a long time, apparently. What I'm suggesting is that ALOA says that a mere complaint is not enough because the Court of Criminal Appeals explicitly called out that it has to be before a court of competent jurisdiction. And without it being before a court that could take the case to trial, it wasn't told. And Your Honor, I'd also like to reiterate that I believe a more correct reading of 1205B is that in the case of a Class C misdemeanor, you have to have a complaint filed to toll it. In the case of a Class A or B misdemeanor, you have to have an information. And in the case of a felony, you have to have an indictment filed. Else, 1201 is a nullity. If the state can toll with only a complaint, then the court would be holding that 1201 doesn't need to be complied with, that the state has no sense of urgency to round up a grand jury and proceed as people are entitled to have. That, you know.
Is a different subject, is diligence, due diligence in play anywhere in here?
Not really, Your Honor. The state's got no duty to promptly bring charges. They have no duty to go search for somebody that they have a warrant out for.
They have a duty somewhat in a revocation situation, don't they?
Just barely, Your Honor.
But there is still one. Is that statutory or did the court create that?
That's statutory, Your Honor. But that's, yeah, that's
The
enforced
statute
away.
says they have to use due diligence in arresting the person within the period of probation or whatever.
Yes, Your Honor. But all I'd like the court to hold is that in the event of a felony, if the state wants to bring the charges, they should have to get at least an information filed, even though this court about a decade ago in Fanner, a case out of Wilbarger County, said that proceeding to trial on a mere information is void. But they should have to have at least an information filed with a court, and preferably an indictment as 1201 requires. Because the legislature didn't put it in there for no reason.
Thank you, counsel.
Your Honor.
May it please the court, counsel.
Just make sure you speak up, please.
Yes, Your Honor. I first wanted to address the issue that was raised near the end there of whether the state does and acknowledges an affirmative duty to promptly bring charges. There's no question. That is what this case is about. Did we promptly bring charges against Mr. Mungia within a time period that constitutes due diligence on our part? Now, there is no duty at law to arrest promptly or timely. I don't think anyone knows what that would mean. There is no timely arrest in my book. But here, what we had was a duty to charge him within that statute of limitations, which is what we did by executing the felony complaint. To your earlier question, Your Honor, yes, the complaint was signed and it does meet, we did not brief on this issue, but it does meet the elements of an information under Drummond.
You signing as the notary, that is enough, in your view, to fall within the statute that says an information has to be signed by the district attorney?
Yes, Your Honor. It does differ from some of the case law that was cited too.
So if you had an information that was signed by a non-different district attorney, but somewhere on there, I don't know, information has an acknowledgement or something else, or certificate of service or whatever, appeared the DA's signature, you'd say that's enough, because somewhere on that document, even though it's not in the area where the DA is making the presentation of the accusation, but somewhere on that document is DA's name, that's enough.
No, Your Honor. The intent of the state to charge the individual with committing an offense is what is required. For an information, it's specific in the statute that an assistant district attorney has to sign that document in order for it to be valid. And therefore, if we would not make the argument, in my opinion, that it's a valid information if we're merely signing it to sign off for someone else.
But again, I think it's Drummond, where they said, we don't have to worry about the complaint here because it's had the requisites of the information. And it doesn't say how it had the requisites. It didn't focus on, well, whether or not the complaint merely carried the DA's name as the notary. You're saying carrying it as a notary, the name as a notary, is enough.
I'm saying that assuming that we are the ones charging the offense out of our office, which in this case is what happened, in this sort of case where we have generated the probable cause language that's included for purposes of receiving a warrant, where we have generated the elements of the offense that we believe are met, and that we have probable cause to charge them with, yes, Your Honor, I'm saying that we're then signing it as not affiant, but not merely notary. We are also signing it with the purpose of filing it in the court of competent jurisdiction.
Even though in the complaint it's the officer making the accusation.
In this case, as in Drummond, the reason that I say that it does still qualify as an information is even though the affiant signed that information as well, this is different from many of the other cases cited too, and including the ones cited in Bonner by this court, that essentially what they were looking at and what they called a complaint was an affidavit from perhaps the victim, right, from somebody else. It wasn't even law enforcement swearing out the complaint. And for that reason, it was considered a true complaint only, not having any kind of legal charging force, because clearly a victim cannot file a complaint that has that authority.
Okay, so we're talking a lot about the complaint, but doesn't the Constitution require an indictment or an information?
The Constitution, Section 5, Article 12, specifically notes only information and indictment as invoking the jurisdiction of the court. However, the Bonner court was well aware of that amendment to the Bonner did occur after that was amended in 1985. The opinion did.
So Bonner was?
92, I believe, Your Honor.
92, okay.
Yes.
All right.
And the Bonner court specifically found that a complaint invokes the jurisdiction of the court. And I think that is the point that we're trying to make as far as Mr. Mungia's arguments here, is that's the controlling issue, is whether or not the filing of that complaint invoked jurisdiction, which is a direct quote from Bonner. The filing of the complaint. But I don't believe so, Your Honor, because invoking jurisdiction requires subject matter jurisdiction, requires personal jurisdiction over the defendant. That's what the Court of Criminal Appeals has said.
Was the complaint in Bonner filed with the district court?
Yes, Your Honor. To my knowledge, it was.
The complaint was.
Yes.
The complaint here wasn't.
Complaint here was as well. So the way that things are handled in Potter County, because they have 5 district courts, and it's the reason, albeit in a footnote, that we requested, if necessary, that this court take judicial notice of this fact. Pre-indictment, the way that the district courts handle cases where charges have been filed but not an indictment is they have one district judge and it's on a rotation. And that district judge, who also handles bringing in the grand jury, is the one that is in charge of those charging documents until the point of indictment. So once the indictment comes in, it then supersedes the complaint, which has been filed in that case. But no, Your Honor, our position is the complaint was filed in the district court, which is the court of competent jurisdiction, and therefore it does toll the statute.
The district judge was the magistrate.
Because whichever of those district judges, I believe the question was asked, does filing it with the district clerk mean filing it with the district court? And the answer is yes, and the citation is in our brief. I believe it's a case out of Austin.
Can a county court at law judge act as a magistrate in a situation like this?
Yes, Your
And
Honor.
if the county court at law acted as the magistrate, clearly a county court at law does not have jurisdiction over a felony.
Right, but we wouldn't have filed it with the district clerk if we were intending to file it with the county court. We would file it with the county clerk.
Do you have any authority for the proposition that the district clerk is the representative of the courts?
Let me find our citation, Your Honor. Yes, it's that Austin case that we included in our brief. My apologies.
Counsel, while you're looking for that,
Yes,
let
Your
me
Honor.
just posit a question raised by Chief Justice Quinn. The Texas Code of Criminal Procedure defines a magistrate and a magistrate's duty. And magistrate can include lower courts. And so what you're saying is, although it's a felony complaint, a lower court can serve as a magistrate and provide them their statutory warnings and set their bond, and all of that's copacetic. And but the complaint itself doesn't go back to their court; it goes to
Right.
the district clerk,
Right. and
because it's the custom in Potter County for the presiding judge of the pending grand jury to take all of those indictments until they are formally presented to the grand jury.
Yes, Your Honor.
And acting as the district clerk acting as the clerk for that court.
Yes, Your Honor. And this is why Bonner relied on the Ward case for purposes of determining this issue of jurisdiction. Because the issue in Ward was the district attorney's office filed its complaint with the justice court seeking a warrant, which that magistrate judge is perfectly able to give. However, the reason that the Ward court, which even though it has been overturned by Ulloa, the main reason for that overturning was because it was pre the amendment to the Constitution, which Justice Parker referenced. However, I believe that the Ward case, were it to occur today, the same issue where the complaint was filed in the wrong location for trial purposes or for invoking the jurisdiction of a court of competent jurisdiction, that it would still be decided the same way. That there, in such an instance, if we were to file our complaint not with the district court, then we are unable to avail ourselves of the tolling of the statute of limitations, which is what was held in Ward. In Ward, they ruled against the state and said that we did not invoke the jurisdiction of that court.
Some of the cases cited indicated that the indictment alleged the tolling, but the indictment in this case didn't.
That's correct, Your Honor. And my understanding as to why it wasn't an issue that was raised by Mr. Mungia was the simple fact of the matter, it is a substantive issue in the Code of Criminal Procedure whether we can amend on that basis or not. But my understanding from reading through the case law is we can amend on that issue without much argument. And if the case were to be dismissed for that reason, they did quash the indictment, we can still bring, we can refile the case. And the tolling that we allege occurred would still qualify for the future indictment. Therefore, it's a moot point is all I'm trying to say as far as whether we had the language on there or not.
Did you find that statute? You said it's in your brief?
Sorry, Your Honor.
I know I've encountered a statute that basically says something along the lines that district clerk is the person who's in charge of the records of the district courts and things like that. But as far as acting as the representative of the district court.
It wasn't a statute, Your Honor. It was a case that we cited to. And my apologies, I do not know why I'm having such a difficult time finding it, Your Honor.
Well, was it the Larry versus State case?
That sounds correct.
Okay, well, that one appears to be a misdemeanor case, which was filed in a county court at law.
Yes, Your Honor.
So how is that?
The equivalent, the state argues the equivalent is at least true. If filing in the with the county clerk's office constitute a filing with the county court at law, I believe that it's fair to at least argue that the filing with the district clerk constitutes a filing with the district court.
What does that do to all our opinions, not just ours, but other courts in a mandamus setting where someone files a motion asking the trial court to do something? They file the motion with the clerk, and the court sits on it. They ask us for mandamus relief to direct the court to act on it. And we said they have to prove that the court had knowledge of it. If filing with the clerk, we said it's in those situations, filing with the clerk is not the equivalent of filing with the court. It doesn't give the court knowledge of that. Is there a different rule in criminal? Or are we wrong in the mandamus setting?
Not to my knowledge, Your Honor. I do believe that it is different with the criminal side of things. For instance, there was much spoken of at the trial, in the trial court hearing of this matter about providing notice to the defendant. That is not, notice can only be provided, for instance, after arrest. Same with this matter. To Mr. Combs' earlier point, none of this, outside of the legal arguments revolving statute of limitations, nothing with a criminal proceeding can occur until that individual is arrested. So to his point of being able to try a case, even if we do obtain an indictment, if the individual has not been arrested yet, a capias has to be issued. That person has to be arrested. We have to know for sure that that's the right person that we're charging with an offense. We have to know for sure that what their criminal history is and that we can prove it or not, especially in a DWI third or more instance. So all these things only take place after arrest. So the idea that we're going to try and indict a case under indictment, despite the fact that, no, we cannot try, under the Constitution, we cannot try a case on a complaint. But we can't try a case on indictment until that person has been arrested anyways. That's the simple truth of it. So all of these things being filed with the district court, what that does is it gives them, upon their arrest, it does give them adequate notice through that court, and then they are appointed counsel through that court as well for their defense. None of these occur via to my knowledge, the JP who magistrates the individual does appoint counsel for them. This all happens through the district judge, because that is the person who has knowledge based on the complaint of what is going on. So the purpose, in my view, is not only to give notice to the defendant, but to the court of what this individual is charged with, which somewhat differs from your description, Your Honor, of the mandamus issue or rules, at least in my mind. I hope that was an adequate answer.
Thank you.
If y'all have nothing further, the state respectfully requests that this case be affirmed and the trial court's ruling as well. Thank you all.
Thank you. Rebuttal?
Yes, Your Honor. All right. Well, Your Honor, the first thing I want to address is the whole issue about Bonner and the constitutional amendments and Ward. The Bonner decision out of this court did not consider, or at least didn't ever mention, the constitutional amendments that were just after Ward was decided. What the Bonner decision did kind of hang its head on was the Court of Criminal Appeals opinion in Ward. I think it was perhaps just overlooked by a briefing counsel in Bonner that no one brought up, oh, hey, we got these brand new constitutional amendments that say complaint's not enough. So that's...
Let me ask you this. There are several provisions in the statute addressing limitations. One is the one that I mentioned earlier, excluded from the calculations is the time that or the complaint pended or something like that. I'm paraphrasing it. And then the statute goes on, legislature went on and defined what it meant by pended, or during the period it pended or something like that. And it refers to pending it within a court of competent jurisdiction.
Yes, Your Honor.
Correct? Did we address that in Bonner? Was that statute in effect at the time of Bonner? And did we address it?
Your Honor, the language in 1205B was, I believe it was identical when Bonner was decided, but I don't think the issue is really raised about procedurally how Potter County does things with felony complaints, because...
But did we address that aspect of the statute in the Bonner that was defining pending, what pending meant during the time it pended?
No, Your Honor.
Okay.
That exact question of whether or not a complaint is actually pending before a court of competent jurisdiction wasn't explicitly addressed one way or the other. And
would you suggest that was one of the defaults in Bonner?
Well, Your Honor, there was that, the fact that it didn't consider the constitutional amendments, and that I believe it was a wrong take on statutory interpretation. Because, specific controlling the general and whatnot, Your Honor.
Well, if you look at Chapter 12, which is entitled Limitation, and then Article 1201 deals with felonies, 1202 misdemeanors, Article 1203 aggravated offenses, 1204 is the computation of time, 1205 is absence from the state, and then in time of pendency of indictment. 1206 is an indictment is presented when it's been duly acted upon by the grand jury and received by the court. And then Article 1207, an information is presented when it's been filed by the proper officer in the proper court. The only other time the word complaint is mentioned is in 1202B, and that's in reference to a Class C misdemeanor.
Yes, Your Honor.
So it looks like the legislature contemplated within the limitation statute, it addresses those. Just a plain reading of it would support perhaps your position here with regard to, well, I guess that the complaint is not referable to a felony, and with Constitution, case law, it's an information or an indictment.
Well, that's how I
Is that-
see it, Your Honor.
Is that the gist of your position?
Yes, Your Honor. And it's.
And that doesn't require a tortured reading of any of it.
I don't believe so, not at all, Your Honor.
I mean, even general over specific, or?
No, I think reading it conjunctively out of 1205B is contrary to what the legislature intended. They could have written it better, perhaps, but I think allowing a mere complaint to toll the limitations in a felony leads to an absurd result. And that's never the legislature's intent.
Because they did make provisions for the complaint in, or what is a complaint in 1202B.
Yes, Your Honor. And out of time, Your Honor, so.
Any other questions? No. Thank you, counsel. Time
Well-
has expired, as you noted. The case is submitted, and you are free to go, and we will be in recess. And I do want to thank you for agreeing to travel down to Lubbock to make the presentation.
Oral arguments are always fun, Your Honor.
And we're glad that we're doing them in person again, too. We still do the Zoom every once in a while, but it's nice to be able to be in the same room with the attorneys. Thank you.